Okay, in recent videos, we went over the pretrial conference statement with regards to the stipulations page, everything that everybody agrees to, and the issues page, what the trial judge needs to address. Now we need to go over the exhibits and the witnesses page. The most important thing here is that any exhibits that you intend to introduce at trial need to be listed at this point. They need to be listed at the mandatory settlement conference. The Labor Code provides that if a document is not listed at the mandatory settlement conference, it cannot be introduced at trial. There are some rare exceptions, but it is an uphill battle. So you really need to put effort into filling out the pretrial conference statement as completely and accurately as possible, because waiting until you get to trial to tell the judge, hey, judge, I forgot to tell you I want to introduce this report, it is a tough battle. There are some rare exceptions. The most common one is that primary treating physicians' reports can still come in at trial, the idea being that you're still treating even as the case goes on. But generally, if a report or a document is not listed on that exhibit sheet at the MSC, it's not going to be introduced as evidence, or at least it won't be admitted as evidence. So you want to list everything. What do you list? This is where you turn your focus generally back to the issues page. Anything that you've listed as an issue needs to have evidence to support it. Either it will have evidence through document, it will be an exhibit, or it will have evidence through testimony by a witness. It may be you, it may be another witness that you call. So you want to go through your issues page and everything that's listed as an issue, everything that the trial judge needs to make a ruling on, either in your favor or in favor of the insurance company, you want to have evidence to support it. So any exhibits that support those issues, if you listed as an issue employment, the employer is claiming you were not an employee on the date in question, you're going to want to introduce personnel documents, payroll records, that type of thing. If you listed permanent disability as an issue, you're going to want to list any QME reports, any primary treating physician reports that rebut the QME or that find a different conclusion. Any reports that establish the level of permanent disability, you would need to introduce those. When I was a trial judge, I would often see injured workers come before me at trial all over the video system and telephone system that we've been using as of late. But the injured workers would say, I'm disputing the conclusions of the QME. I don't agree with that doctor because my injury was worse. My permanent disability level should be higher. But what they often didn't do was introduce evidence for me to rely upon to find that the medical reporting of the QME wasn't substantial or that the permanent disability should be higher. So anything you're putting before the judge, you want to go in with evidence to say, here I'm relying on this. It is a much more persuasive argument than saying, I think the reporting is wrong and it should be something different. So whatever your issues are, you need to introduce evidence. If your issue is dispute over your job occupational code or occupational group, you'll want to introduce personnel records that support the type of work you did. Likewise with witnesses, you'll generally call witnesses if there's a dispute over whether or not the injury occurred. So you may call coworkers who saw you fall down or coworkers who saw the injury take place. That would be the time you would call witnesses. And keep in mind, with regards to witnesses, the rule is generally the same as exhibits. If an exhibit is not listed at the MSC, you're generally not going to be allowed to introduce the exhibit at trial. Likewise with witnesses, if you didn't list a witness at the MSC, when you get to trial and you tell the judge, by the way, I want to call Mary Elizabeth, my coworker, she can testify as to what happened. If you did not list Mary Elizabeth, At the MSC, it's almost a guarantee that the defense attorney is going to object, and if you didn't list that witness, it's going to be very difficult to introduce that testimony. So, again, the most important thing here is spend time preparing your exhibit list, spend time preparing your witness list. If you're in doubt as to whether or not you may introduce an exhibit or you may not, the safest bet is always to list it at the MSC. There's no requirement that you have to introduce it as an exhibit. You can change your mind at the trial or just before the trial and not introduce the exhibit. But again, if you think you're going to need it, you need to list it. What do you list? Anything that supports your position as to all of the issues that you've put forth for the judge. This is a very general video as to what gets listed for the exhibits and the witnesses. In other videos, we'll go more into detail as to more of the strategy.